Hello again, ladies and gentlemen. This is Brian McClanahan, and today we're going to talk about the Imperial crisis. Now, I set up this particular presentation and presentation 2 by discussing the various colonial charters, which the founding generation, essentially, or that first generation who were here, called the ancient constitutions of their fathers. So it wasn't just the actual unwritten British Constitution that the founding fathers were alluding to when they said you were protecting our ancient constitutions, our rights as Englishmen. It was also those colonial charters. So if you go back to presentation 2 and review those, and I've given you the colonial charters for essentially every one of the 13 original colonies, you can see where they're coming from with that. And so as we move through this particular presentation, I'm going to actually recap some of the things that I've already discussed and some of the issues I already brought up in the first presentation on this particular issue. But I'm going to go into a little more detail with some specifics as we move through, say, the 1760s into the 1770s, and we start looking at what actually brought about this particular war for independence as a constitutional crisis. And that's the main theme of this course. Of course, it's a constitutional history. So you're often told that the American War for Independence was a war over taxes. So taxes, taxes, and more taxes. Well, of course, that was part of it. But that was an issue within this constitutional crisis. So the founding generation weren't concerned about paying taxes. It was, they didn't want to pay taxes that were unconstitutionally levied on them. So the taxes they were paying, in fact, were very small compared to the taxes they would have been paying if they lived in England, for example. But these taxes were unconstitutionally levied because they were not levied by the colonial legislatures themselves. They were levied over in England by Parliament. So that was the rub. And as we go through this, you'll see what I'm talking about there. So, it wasn't just that they had these taxes and, my gosh, these things are too high and we don't want this as a tax revolt. Well, certainly there was some element to that, but again, it was the way the taxes were brought on the colonies. It was the type of constitution that they were having to follow at the time, and it just wasn't what they were used to. It wasn't following the ancient constitutions that they had established for close to 100 years at that point. So really, this particular war is a constitutional struggle, as I said. Now, in the first presentation, I talked about this general welfare. I mentioned it once or twice, in presentation 2, I should say. I mentioned this once or twice. And that phrase, of course, is in the United States Constitution. It was in the Articles of Confederation. And they actually used that phrase in this period, this 10-year period or so leading up to the War for American Independence. And what they meant by that, of course, is that Parliament and the British Empire was responsible for the general welfare of the colonies. And that didn't mean going out there and providing a welfare check for people. It meant that they were entitled to regulate trade, to perhaps build some infrastructure if they thought that was necessary, to protect the colonies. But really, more than anything, it was commerce and defense. They wanted to ensure that the colonies remained a free commercial area and that they were protected. And that was it. And so when we look into the United States Constitution, and of course the Articles of Confederation, I'll talk about this when we get to those presentations. When Roger Sherman said, when he added that phrase to the Constitution, he said, well, look, that's what it is. It's commerce and defense. And this idea actually went all the way back to the colonial period. So it's not hard to figure out what the founding fathers intended by the general welfare of the United States, because here it is in the colonial period. It's the same thing. And I think that when we take that phrase, that clause, quote-unquote clause in a vacuum, that's when it causes all kinds of problems. I've also discussed in the presentation 2 the Parliament versus the colonial legislatures, and we looked at those colonial charters and how each colony had a legislature that was designed to handle the local concerns of that particular colony, which included currency problems, taxing problems, internal trade problems, all the things, the court system, all the things that the people needed to have effective government. They didn't think that Parliament from the outside should be able to force its hand on the colonies in that particular way. So really what we're talking about here is local versus imperial control. That was the major concern when you're talking about these colonies at the time. So local versus imperial control. Now, between 1689 and 1763, you had the abridgment of these ancient constitutions. Now, or in this particular period of time, you had the not necessarily the abridgment of these ancient constitutions, but these things were defined, I should say. First and foremost, you had the Navigation Acts and Parliamentary Supremacy. So before 1689, if you look at the legislative history of the North American colonies, you had something called the Navigation Acts, which were designed to regulate trade. But those acts were hardly ever enforced, and by 1649 even, Virginia was starting to resist parliamentary authority in this particular area. What they said was that by removing to North America, the colonists had been left without, and I have put a quote here, those privileges in the Parliament of England which their fathers had, which means they had no control of that Parliament in England. So by coming over here, they've actually established something completely different. And they had to have local control of these concerns because they could not have control in the Parliament. They weren't represented. So if you've heard that phrase, no taxation without representation, what the colonists were even saying in 1649 is we're not represented in Parliament. So therefore, Parliament has no control over these colonies. So parliamentary supremacy was unconstitutional. They couldn't do it. Now, you had the Navigation Acts again, designed to regulate trade. But because that was a messy business and because the Parliament had no idea what was going on in the local concerns of the colonies, there's no way they could regulate trade from London. And this is simply what the colonists are saying. And again, if you fast forward, just to 1775 and then maybe, to 1860s here in the United States and even to 2012, what many people who are arguing for states' rights are saying, or at least local control are saying is, look, there's no way Washington, D.C. can micromanage. There's no way Washington, D.C. can micromanage in 1861, and there's no way the Parliament can micromanage in 1775. This is how this idea of local control fostered itself here in the colonies. It was brought over here because of the fact that these people removed to the colonies in the first place. Parliament couldn't do it, and they could never be represented. The colonies could never be represented in that Parliament. In fact, I put another quote here. The King and Parliament had not more right to make laws for us than the Mohawks. Nothing could be more tyrannical than our being obliged by acts of Parliament to which we were not parties to the making, and in which we were not represented. This is the governor of Rhode Island, Stephen Hawkins, saying this in 1757. Not in 1775, in 1757. 20 years before the war began. The governor of Rhode Island is saying, you know what, Parliament, you cannot legislate for us because we weren't party to those laws, and you have no idea what's going on here in Rhode Island. British officials also openly complained of the sour attitude toward parliamentary authority in North America. They said, look, these people out here, they don't want to follow our rules. We pass laws, and we try to enforce them, and they just reject it. This is the ultimate issue of nullification, because what you have is people saying, yeah, you pass a law, but we're not going to follow it. We refuse to obey your laws. By their refusal, they're saying your laws are void. And I think that's something we have to understand today. By assenting to laws, by allowing these laws to be passed, and then by agreeing to them, we're basically saying these laws are okay. But by your refusal to participate, you're actually nullifying those laws. So that's something to remember as we move forward. Now, before the French and Indian War, colonial leaders often wrote and spoke of the importance and supremacy of the colonial constitutions in relation to unconstitutional parliamentary acts. So again, this goes back to that presentation too. We had these colonial charters, and of course, those colonial charters oftentimes had codification of, say, liberties that they thought that they needed to be protected, and written down. Liberties they already had, but yet they wanted to ensure that the government didn't infringe upon those liberties. They also had established a general framework for legislatures and the powers of those legislatures in relation to the royal governors. So when I say what do these colonists mean by the constitutions, what they meant was laws of their own making. Colonial legislative powers, the liberties and privileges inherent in Englishmen. These are things that they already had in British North America. Of course, they said they brought them over with them when they came here on their own hook, by the way, their own blood most of the time. I mean, they're doing this on their own money, their own toil. I mean, there's nothing over here waiting for them. It's not like the British Parliament is saying to them, well, here's, $1,000, go to it, or here's £1,000, go to it. Most of these people are doing it on their own. So when they get over here, there's a tremendous amount of independence. They still believe they have all the rights and privileges that they had before they came here, and of course they codify these things in these colonial charters, and then of course these early colonial constitutions. These were laws of their own making. So when their parliament made a law, they assented to that law. But when the British parliament made a law where they weren't represented, they didn't assent to that law, and so therefore they're going to refuse to abide by it. Now, 1688 is an important year, of course, in England because of the Glorious Revolution. And, of course, that brought parliamentary supremacy to the forefront because the king, in so many ways, King William, with William and Mary, the king was emasculated in some ways in that he didn't have as much control as he had before 1688. So Parliament now becomes a supreme legislative authority. The king, of course, still has a role in that, and that didn't go away for many years. But by this point, Parliament is saying, we are supreme, and you're going to do what we say, whether it's in London or the rest of England or in the colonies themselves. So this is actually a quote from Jack Green, and I cite his book at the end of this presentation, and everyone should read it. But he says, for the development of the British Empire as a whole, then, perhaps the most important results of the Glorious Revolution were the localization of power and the growth of parliamentary institutions, not just within Britain, but also in Ireland and the American colonies. So what he's saying is, even though you have this parliamentary supremacy, you're actually developing a strong parliament in 1688. You're also seeing that same trend now all throughout the colonies. This unleashed parliamentary power. See, these colonies had their local charters, and of course they had their local legislatures, but what he's saying here is that now we've had this Glorious Revolution, we see that Parliament is supreme. These local institutions are saying, well, we're also supreme. Our Parliament is supreme. We're all governor, you can't legislate for us, or, just because you're a representative of the king, you don't have all the prerogative here. You don't have all the supremacy. Same thing in Parliament. Just because you're over in London and you're saying you're legislating for us, you can't do that because you don't know what's going on in our particular colony. So colonies, of course, had long possessed the ability to pass laws of local concern free from parliamentary meddling. They had been doing this for years. They've been doing this since they established the colonies themselves. And Parliament had no right to do it for them. And this is what the main constitutional rub was, of course, leading up to the American War for Independence. Now, you've often heard this idea the British threw around called virtual representation. And, of course, what Parliament would say in England is, well, you're virtually represented. We legislate for all Englishmen, all British subjects, regardless of where they are. We legislate for the people in Virginia. We legislate for the people in Ireland and the Bahamas. It doesn't matter where you are. You are our subjects, and so therefore we are supreme. And of course, the unwritten British Constitution, which, the idea that you have the legal system basically established constitutional precedent, was supreme. But the colonists had a different tradition because they had actually written down, they had codified some of these liberties, and they had written down a constitution in their charters. So they were establishing a framework of government. So you actually start having these two divergent constitutional traditions in both London itself and also in the colonies. So what the colonists start saying, well, if they're virtually represented, then why did Parliament for over 100 years allow the colonies to pass their own taxing legislation? If we're virtually represented, then you should have been passing all the taxing legislation up until this point, but you weren't. So we passed our own taxes, we passed our own currency laws, we had our own trade laws, and you didn't say anything about it. But now 1764 rolls around, and of course this is after the French and Indian War. You need revenue, and so now you're going to put your thumb on us and say, you got to pay. This was a problem, because for forever they didn't do this. For over 100 years, since 1620, since 1607 basically, they didn't do this. And now you're going to? The colonists said, no way, we're not going to allow this to happen. Now, in 1764 you actually get two taxes. In 1764 and 1765, you get two taxes. The first is the Sugar Act of 1764, which was an indirect tax, and the Stamp Act of 1765, which was a direct tax. Now, what I mean by indirect and direct? Well, an indirect tax is a tax that regulates trade, essentially. A direct tax is where they say, okay, we're going to raise revenue and we're going to tax this particular item. And you see it. It's a Stamp Act, they actually stamped it on the paper. It's no different than, say, like a sales tax today. It's a direct tax. Indirect tax is where they say, okay, we're going to regulate trade, so we're going to actually issue, import or export taxes, and that's going to increase the price of a good. But it's indirect. You don't really see what's going on. We're regulating here. Now, the Sugar Act did not cause the same stir as the Stamp Act because it was a regulation of trade. And again, this was part of that general welfare idea. Well, the British Parliament can regulate trade, so that's providing for the general welfare. Okay, well, we can understand that. But the Stamp Act was a direct tax on the colonies, a tax they did not approve, nor could they approve without representation. So they would pass their own Stamp Act in the colonies if they wanted to raise revenue, but they wouldn't allow the British government and Parliament assembled to do that for them. If they wanted to have a tax, a Stamp Act, they could do it, but the Parliament couldn't. Now, what the colonies are going to do, of course, is respond in the Stamp Act Congress. So in 1765, 9 colonies met. They produced something called the Declaration of Rights and Grievances of 1765. And essentially, when you look at this thing, it's very interesting. It was a restatement of the colonial position for the last 80 years, namely local control of taxing policy. They have been saying this since the 1680s. Look, we have control of our taxes. You don't. So you can't pass this Stamp Act. The colonial constitutions were threatened, so the colonists took action. I mean, that's essentially what this is. This is a constitutional crisis, not a tax revolt. And as I said before, taxes were lower here than they were in Great Britain. They're saying our constitutions are being destroyed. You can't pass these taxes. The colonies then offered a hedge against parliamentary power. So when we look at later on, when we start talking about the United States Constitution, the states then would take that position. This is all Jefferson and Madison are saying in 1798 in the Virginia and Kentucky resolutions. The states were offering a hedge against the federal legislature. Here, the colonies are offering a hedge against the Parliament, the British legislature. Now, in 1767, the Parliament will reassert its authority through something called the Townsend Act. So we had the Stamp Act crisis. The Stamp Act is then repealed. And Parliament, just 2 years later, will come back and say, well, you know what, we can still pass these taxes. Just because we repealed it and you hurt our wallet doesn't mean we're not going to do it again. So the Townsend Acts would reaffirm parliamentary constitutional authority over the colonies. They said that all taxes were external, meaning that Parliament could arbitrarily levy taxes at will. So your taxes are not internal. Taxes are external. We decide what taxes are, and you have to abide by them. And essentially, this is what the United States government does today. All taxes are external. You have state taxes, but you know what? Our federal taxes are supreme. We can do whatever we want. We can pass healthcare legislation, call it a tax, and say that you're going to pay it. This is exactly what's happening in the 1760s. Nothing's new here. It's the same thing. The Parliament said there's no distinction between local and empire. Though some forward-thinking British leaders like William Pitt the Elder and later Edmund Burke saw things a little differently. And what they're trying to do is centralize the empire with the Townsend Act. So this is centralization running wild here in 1767. Again, it's a constitutional crisis. It's the same thing we have today in the United States. You always have that central authority trying to usurp power from the local, because that local is going to resist the central. This is a power play. The court or municipal area, the parliament, against the country, the local authority. So this struggle that we've been waging here in the United States, essentially since the Constitution was written and who actually has the power, it's nothing new. This same thing was going on before in the 1760s and the 1770s. The only time you really didn't have that was under the Articles of Confederation, because it was actually written in the document that the local had all the power. But once you start giving power to a central authority, that central authority is always going to try to bring it to itself, arrogate that power to itself, and then, of course, the local is left out in the cold, sitting there saying, well, we still have the power. We've always had the power. But, of course, the central authority will say, no, we've always had the power. Now, John Dickinson is going to produce something, of course, great founding father in 1767. He's going to write something called The Letters from a Farmer in Pennsylvania. This was a conservative treatise on Parliament's constitutional authority vis-a-vis the colonies. So he's saying, look, we've had these written constitutions. You have your parliamentary power, but we're still supreme. He said, Parliament could not levy internal or direct taxes without the consent of the colonial legislatures. By 1770, the Townsend Acts were limited to a tax on tea alone, meaning Parliament, though unwilling to admit defeat, agreed that taxes could not be levied on the unwilling. So we're saying, look, we can still tax you, but we can't levy taxes on unwilling individuals. Even some British leaders conceded the right of no taxation without representation and thought virtual representation was no representation at all. So they're saying, look, we're saying that they're virtually represented, but we all know they're not. And we can't levy taxes on them unless they're going to concede to these taxes. So by 1770, the Parliament has said, well, yeah, the Townsend Act, the tax on tea is still in effect. We still have supremacy over you, but basically by repealing the other parts of the Townsend Act, they're saying, we don't. Now, in 1773, you're going to get something called the Tea Act. Now, this is a misunderstood law, notably because of the tea parties that sprang up in Boston, Charlestown, and Annapolis. What they were worried about was a potential monopoly of the British East India Company, not the tax on tea that they've been paying for 6 years. They'd already been paying this tax. But they worried about this monopoly that the British East India Company would potentially have. And actually, if you look at in Massachusetts, in their colonial charter, they actually had, in their Declaration of Liberties, they actually had a clause in there that said, you can't have monopolies. So here we have in 1773 a monopoly. Now, American resistance to government monopolies and corporations was born long before the Jeffersonian critique. I mean, as I just said, you had it in Massachusetts. So here in 1773, they're saying you can't have a monopoly on the tea trade. So again, this goes all the way back to the colonial period and all the way back into the 1600s. By 1774, you have a crisis which was no different in many aspects than the American crisis of 1861 to 1865. Parliament refused to acknowledge over 100 years of custom and colonial constitutionalism. They insisted that the empire had one authority, sovereign and supreme, and were one people. Does that sound familiar? The United States government in 1861 is saying that we have sovereign and supreme legislative authority over you, and we're one people. This is Lincoln's Gettysburg Address. And this is what's happening in 1774, 1775, and 1776. This is what was happening with people like Hamilton and Marshall and all these nationalists during the American period leading up to the war between the states. No different. We're one people. We have one legislative authority. Everything's, the central authority is sovereign. The states have lost all their power. There's no local control. So when you look at people like Abraham Lincoln and Alexander Hamilton and John Marshall and Henry Clay and Daniel Webster, they're the British. And the individuals who were resisting this, people like Jefferson, of course, Madison ultimately, and Abel Upshur and John Tyler, and all the individuals who were part of the secession conventions, and of course 1860 and 61, and also the individuals who were fighting against parliamentary power in 1775. They're the Americans. This is what Americans couldn't understand. The American tradition was born in 1775, and even before that, just by coming over here, the American tradition is born. We have local control, the central authority doesn't, and so therefore you can't legislate for us. The colonies maintained their resolute defense of local authority over domestic concerns. Imperial law was typically ignored in deference to local custom. This was not lawlessness or mob rule. This is what people don't understand about nullification. It's been said before, and many times, well, that's lawlessness. No, it's local custom. And it's not central control. There's still law here. There was still law in 1774, 75, and 76, but it wasn't parliamentary law. So the central authority didn't like that, and they tried to, of course, clamp down on that. By 1774, you have the rights of Englishmen abridged. You get the Coercive Acts of 1774. You get the expansion of the Quartering Act of 1765. You get the attempt to disarm colonial militias in Massachusetts in 1775. Of course, Britain was aiming part of the Coercive Acts at the Massachusetts legislature by placing the colony under the direct control of the royal authority, in essence revoking their colonial charter. So they took the colonial charter away. They destroyed the Massachusetts Constitution. The general court ceased to exist. This was the real threat to English constitutionalism. And if they could do that in Massachusetts, why couldn't they do it in Virginia or New York or Pennsylvania or South Carolina or New Jersey? I mean, if they can do this arbitrarily, what's to stop them in all the colonies from revoking the colonial charters, from revoking and basically saying these colonial constitutions don't exist? If they don't exist, we lose our local authority. So this is really where it's a constitutional crisis. Yeah, you have the Coercive Acts and they're horrible, and you got the Quartering Act and close down the Boston port and all these other things. The Administration of Justice Act and so you have this all these things going on within the Coercive Acts. But really, what they're saying is, you've closed down our government, you've destroyed our Constitution, and we're not going to stand for that. So fear of the expansion of such law drove many colonists to the final break. And the nice example, of course, is Patrick Henry's Illusion of Hope speech, which people know as "Give me liberty or give me death." he says in this particular speech, if you read it very carefully, look, we've been trying to resist parliamentary usurpation of our authority for 10 years, and what can we do now? I mean, it's over. Our ancient constitutions are being destroyed. I have but one lamp by which my feet are guided, and that is a lamp of experience. And I want to know what's been going on for the last 10 years to say that this is going to get any better. Parliament is increasingly centralizing its power, and they're going to take our colonial charters, and they're going to say, you're under our thumb, we can do exactly what we want, and you have to agree to it. They're destroying those rights of Englishmen and their ancient constitutions, which had been established for over 100 years. Henry, of course, had asserted as early as 1765 that Virginia was independent of Britain in its local affairs. So, long before he gave this very famous speech in 1775, he had said in 1765, we're independent of you. We're independent in our local concerns. You don't have the right to legislate for us because we're not represented there, and our local constitutions are supreme to yours. So, the secession of the American colonies and the establishment of states equal to the state of Great Britain, this is essentially what's happening in the Declaration of Independence itself, which of course Dr. Gutzman will talk about. The colonists and Jefferson in this declaration asserts that the colonists now are free and independent states, that they're equal to the state of Great Britain. And he calls it that. He calls Great Britain a state. So by saying that these colonies are now states, they have equal footing with Great Britain or France or pick your state across the world. That's what they are. So now the local has become supreme. It's codified. And eventually when they get to the Articles of Confederation, which of course we'll talk about in another presentation, that's what happens. The states become codified in that, and the local becomes supreme. So American constitutionalism will take the next step here. Also, Delaware will secede from Pennsylvania in 1776. And American Republican government was derived from the British model. So the British model, which of course has been established since the 1600s in the colonies itself, this was not something new. This idea that the colonies are supreme in their local sphere of influence, their local concerns, again, taxing, intrastate, I should say, or local trade, currency issues, these type of things, the court system, all these things were of local concern. And the central authority, that general welfare, was for commerce and defense. That was it. That's all the central authority needed to do. And of course, this was pointed out many times. It's been pointed out for over 200 years now. This is exactly what the founding generation were talking about. But of course, anytime you have a central authority, it's always going to try to take that power from the local because that's all it can do. That's all it knows how to do. And this was a great fear, of course, with the Constitution. So I've listed here Jack Green's The Constitutional Origins of the American Revolution. Came out in 2011. It's the best summary of the preludes to the war as a constitutional crisis. I highly recommend reading it. It's one of those required reading, I think, for this particular course, among with other books that we've also listed for each lecture. So hope this helped you. And of course, we're going to pick this up a little bit when we start looking at the Articles of Confederation, and of course later the United States Constitution. And so keep all this stuff in mind as we start talking about the local constitutions and local concerns and states' rights and local authority and all those things. It all goes back to the colonial period.